Morning or good afternoon, depending on your time zone. Warmest of welcomes to the second Global Experts Plenary in this biennial Global Online Symposium, Human Rights, Sustainable Development and the Law 2026, on respecting human rights in business, trade and investment for sustainable natural resources management. I'm Natalia Pushkareva and I serve as a CISDL researcher, also one of your moderators for this plenary.
Hello and welcome to all our participants. I'm Dr. Jelly Molino, CLGI Coordinator with the CSIDL, and together with my co-moderators, it is my pleasure to introduce the chairs of our second Global Experts Plenary, Respecting Human Rights in Business, Trade and Investment for Sustainable Natural Resources Management. Professor Ilyara Espa is a senior research fellow at the World Trade Institute and a faculty member at the Università della Svizzera Italiana, as well as serving as CSIDL lead counsel for natural resources and rapporteur for the ILA Committee on the SDGs. Her world-leading research focuses on international economic law intersection with environmental and human rights issues.
Hello, everyone. I'm Matthew Carvalho, CISDL Associate Fellow and Coordinator of the Health Law Program. I'm delighted to introduce our other chair, Professor Marcus Gehring is a renowned professor of European and International Law in the University of Cambridge, Fellow of Hughes Hall, and former Director of the Center of European Legal Studies. The CISDL Lead Counsel in Trade, Investment, and Finance. He also holds an ad personam Jean Monnet Chair in European Sustainable Development Law from his time as Vice Dean of the University of Ottawa, having authored many fascinating books and studies on trade, investment, and sustainability. Further, Dr. Fabiano de Andrade Correa is a leading international jurist with the World Bank and CISDL Lead Counsel for Peace, Justice, and Governance with expertise in international economic law, sustainable development, and human rights. Chairs, the floor is yours.
Thanks a lot, our fantastic moderators. It is a pleasure to welcome you to this plenary on respecting human rights in business, trade and investment for sustainable natural resources management. Thank you so much for joining us, and thank you to everyone involved in the earlier sessions. We have some fascinating discussions ahead of us. Our panel sits at the intersection of several development goals, notably SDG 2, zero hunger, 6, clean water and sanitation, 7, affordable and clean energy, and 8, decent work and economic growth. These goals remind us that the sustainable management of natural resources is not only an environmental imperative, but a matter of human dignity, equity, and justice. And this is reflected in the ongoing shift in international law from a logic of control over natural resources to a logic of shared responsibilities for the sustainable use of national, transboundary, regional, and global natural resources. This is also shown by recent work conducted within the CISDL, the Natural Resources Program, and the Trade Program, among others, and the International Law Association, who's also a partner, together with many other institutions contributing to this plenary, in particular within the context of the Committee on the Role of International Law in Sustainable Natural Resources Management for Development, which has led to the adoption of the ILA Kyoto Guidelines in 2020 and to the forthcoming volume on natural resources, sustainable development, and international law, co-edited by Prof. Mary Claire Cordonier-Seger, Professor Nico Shriver, and myself, which is soon to be published by Walter Kluers, thanks to the contribution of 40 plus world-class international law experts, many of them also contributing to this plenary. Now, in light of this shift, the question that for us to address is no longer whether public and private actors have responsibilities with respect to human rights, but how can these responsibilities be effectively translated into legal obligations and meaningful accountability mechanisms? The focus questions in front of us for these plenaries are therefore the following. What are the main international legal challenges and opportunities in ensuring the business, including investors, will respect human rights, especially in relation to sustainable natural resources management? and how my legal developments from WTO MC14 or further innovations in regional and bilateral trade and investment accords foster rather than frustrate human rights and sustainable development. It is our pleasure to now introduce our opening keynote speaker, Professor Damilola Olabuyi, who's UNESCO Chair in Environmental Law and Sustainable Development at the College of Law, Hamad bin Khalifa University, a Vice Chair of the ILA, and together with Professor Mary Claire, one of the co-chairs of our ILA Committee on the SDG, among other important roles, many others, but in the interest of time, I would, without further ado, give him the floor. He's kindly agreed to limit his keynote to 5 minutes in order to permit more rounds of engagement with your questions online. So please do not hesitate to enter them with your name and country into the Q&A chat. Thank you, Professor Olabuyi. The floor is yours.
Thank you very much, Professor Ilaria, for the very kind introduction. And I must start by congratulating the organizers, especially the CISDL, for this great opportunity. As you may already know, I've been very busy in my mandate as a member of the UN Working Group on Business and Human Rights, which is responsible for disseminating and implementing the United Nations Guiding Principles on Business and Human Rights, the UNGPs. Which has been around since 2011. So this year we are celebrating 15 years, commemorating 15 years of the UNGPs. But of course, challenges remain despite some progress made. Some progress have been made in terms of awareness raising. Everyone now knows that the responsibility of implementing human rights is not with states alone anymore. International law now expects businesses to also, take the lead in respecting human rights across their value chains. At the regional and domestic levels, more than 40 countries have now adopted legislation or national action plans on business and human rights, including the EU Directive on Corporate Sustainability Due Diligence, CSDDD, all of which highlight the need for mandatory human rights due diligence and frameworks that address business-related environmental harm. So the awareness is rising, the knowledge is increasing across the world. However, the challenges that remain are still plenty. The adoption of national action plans is still very slow in many parts of the world. For example, in Africa, only 5 African countries have adopted and launched national action plans: Kenya, Uganda, Nigeria, Liberia, and Ghana, and that's in a continent of more than 50 countries. So we still have at least 50 countries that are yet to do anything substantial about integrating the UNGPs within their legal frameworks. And this can be said of many other continents across the world. So one key message that I hope to emphasize, taking the opportunity of this symposium, is the need for countries that are yet to adopt national action plans to do so. Having a national action plan is a clear sign that a country is taking the message of business responsibility for environmental harm seriously. And it's also an indication of what the state would expect those businesses to do. Now, adopting a national action plan is not a silver bullet in itself. There is a need to implement it. There is a need to put it into action. There is a need to avoid business lobbying that weakens regulation in this area. And a lot can be said with some of the challenges facing the CSDDD and the debates around it. There is a need to ensure that we also address other problems that make it difficult to hold businesses to account. For example, in many parts of the world, the high cost of litigation, the high cost of obtaining legal representation, lack of legal aid programs, general delays in the dispensation of justice have been to countries in our mandate whereby when the local communities go to court to challenge an environmental harm, it takes 20 to 25 years for them to get justice. We cannot achieve environmental justice if we have to wait and the litigants have already died while trying to seek and obtain justice. There is also a need for regional courts to foster a common approach an understanding on this subject. And I was very pleased to see, for example, that the European Court of Human Rights recently released its official guide on business and human rights and on its website, which serves as a primary entry point on the evolving jurisprudence in this area. I would like to see the African Court and other regional courts do the same. This not only raises awareness, it also creates an opportunity for advocates and civil society actors to understand the thinking of the courts in these cases, which perhaps could reduce delays. One other issue that I've been highlighting lately is the need for participatory approaches when designing policies and when implementing them. So most times we see a situation whereby one ministry is implementing, maybe, for example, food security programs. One ministry is responsible for designing food security programs, but they do not have human rights mandate. And so they do not include human rights in their design. And so then the Ministry of Justice with human rights mandate has nothing to do with food security. So you then have that gap, and then there is that problem whereby businesses can then easily move through the cracks and continue to perpetuate modern slavery, child labor, and all sorts of environmental pollution. A last part that I would like to highlight is the need for capacity development. Despite the progress made, it is only in few law schools that the subject of business and human rights is still taught. Only very few law schools across the world. Only very few law schools even teach environmental justice, bringing that human rights and environmental dimension together. We all know that studying environmental law does not mean you are taught anything about human rights or justice. Environmental law is a different subject on its own. So there is a need for more capacity development. There's a need for universities to be at the forefront of this, designing and implementing innovative courses. There is a need for more scholarship in this area, and that's why I must commend the effort of the CISDL in this area. We have the new book on sustainable development law, which covers some of these issues. And I hope you find it useful. Myself and Professor Marie Claire and Dr. Tejas work tirelessly. Yeah, I can see Professor Marcus holding it up. I think there is a need to leverage such resources, and also we hope to see more in this area that will expand and advance awareness, thereby reducing this issue of lack of information, lack of resources, lack of capacity that we see across the world. I do hope that today's session can illuminate some of these points. We have a lot to cover. We have a lot of ground to make up across the world. And I hope that we will get that business innovation. Businesses can be the problem. They can also be the solution. But businesses can be part of the solution if they leverage their resources to support capacity in this area, and if they transcend from the mindset of just compliance to a mindset of responsibility. Thank you very much.
Thank you so much, Professor Olaoye, for those compelling remarks, which really do open the conversation brilliantly. A lot to cover, indeed. As you know, we have 3 key focus questions for this plenary, and we especially invite the audience to also add your questions for our speakers using the Q&A function. We have a stellar panel. It is my pleasure now to give the floor to Professor Marcus to introduce all of our expert plenary speakers.
Hello, everyone, and thank you for joining us. Together with Ilaria and Fabiano, who will be providing closing remarks, I will be one of your co-chairs for this plenary, especially focusing on the Q&A. Dr. Fabiano will especially leading the closing remarks. And I would like to thank the hospitality of the Center for Human Rights and Legal Pluralism here at McGill Faculty of Law, where I am. And without further ado, I'd like to introduce our first speaker. Professor Alessandra Lehmann is an internationally distinguished CISDL fellow, leading professor of ESG and climate law, and president of the Brazilian Bar Environmental Law Commission, Rio do Sul chapter. She has received numerous distinctions and prizes for her contributions, including recognition as a Stanford Wood Institute Rising Environmental Leader Fellow and as a Santander LSE W50 Scholar. Professor Lehmann, you've got the floor.
Thank you so very much, Marcus, for the exceedingly kind introduction. It's a pleasure to contribute to today's discussion, and I would like to address our focus questions today from the perspective of international trade law. For quite a while, discussions on business and human rights focus primarily on corporate due diligence or investment responsibility. Today, however, and increasingly so, trade has become an important mechanism for shaping how natural resources are governed. Market access is no longer determined solely by tariffs or technical standards, but also increasingly by the conditions under which goods are produced, resources are extracted, and supply chains are managed. This evolution creates significant opportunities to reduce fragmentation among the trade, nature, human rights, and climate change regimes. But it also poses important challenges, and I believe the law has a lot to contribute in both fronts. The opportunity is that trade can become a powerful driver of sustainable natural resource management. We see this in the growing emphasis on traceability, sustainability standards, responsible sourcing, and environmental and social due diligence across global value chains. Modern trade agreements, regional initiatives, and unilateral trade measures increasingly seek to reward production that respects environmental and social standards. Yet sustainability cannot be measured only in environmental or climate terms. The legitimacy of those measures ultimately depends on whether they also protect human rights. This is particularly evident in the transition to a low carbon economy. Critical minerals such as lithium, cobalt, nickel, and rare earth elements have become strategic commodities indispensable for renewable energy technologies, batteries, and electric vehicles. So governments are increasingly using trade agreements, strategic partnerships, and investment frameworks to secure reliable supplies of these resources. The challenge here, and this is a challenge I believe the law can help overcome, is to ensure that the race for critical minerals does not reproduce the human rights failures of previous extractive booms. Also, when we think energy transition, I also think its success cannot be measured solely by the number of, say, solar panels or electric vehicles we produce. It also depends on how the underlying resources are extracted. So there's a couple of questions we should ask in this context. Are indigenous peoples and local communities meaningfully consulted? Are labor rights respected? Are water resources protected? Are the economic benefits of extraction shared fairly? So if these questions are neglected, the green transition risks reproducing familiar patterns of inequality and environmental degradation under a different label, if you will. So in other words, respect for human rights is not external to sustainable resource management, but one of its very defining conditions. So ultimately, the question is not if trade should influence the governance of natural resources, as it already does so, but the real challenge is to ensure that trade and investment frameworks support a model of development in which economic competitiveness, environmental sustainability, climate action, and human rights reinforce one another rather than compete. If we succeed, trade will not simply facilitate the movement of natural resources across borders. It will effectively help ensure that those resources are managed in ways that are environmentally sustainable, climate friendly, socially just, and consistent with the Sustainable Development Goals. Thank you very much.
Thank you so much, Professor Lemon. And also joining us is Professor Ted Gleason, a CISDL Associate Fellow and Associate Professor at Grenoble School of Management, author, together with our very own Professor Marie-Claire, of a new volume of investment law and sustainable development, which has already been nominated for several awards. His cutting-edge research focuses on international business law, particularly the relationship between investment protection, environmental protection, and sustainability. Professor Gleason also has significant experience as a licensed attorney in investor-state dispute. Ted, you have the floor.
Thank you very much, Marcus, for the kind introduction. I'll focus just in my brief remarks on the investment law perspective and the relationship between international investment agreements and human rights considerations, particularly since the adoption of the Sustainable Development Goals in 2016. I've had a chance to review investment agreements, both bilateral investment treaties and treaties with investment provisions, which have emerged since the adoption of the Sustainable Development Goals. Of course, human rights can be considered among the foundational constituent elements of the Sustainable Development Goals. And in this research, it's become apparent that certain constituent elements of the Sustainable Development Goals, such as environmental protection, as well as creating better working conditions, have been adopted in recent international investment agreements to a very high degree, and in many cases using strong binding language. Indeed, environmental protection is at least referenced in almost, with very few exceptions, almost all international investment agreements in recent years. Labor standards, working conditions in about over 80%. And again, oftentimes using binding language. The depth of commitments does vary, of course, from one agreement to the other. But in the environmental protection context, especially, we do somewhat regularly see language such as the following language. For example, language saying that each member state shall strive to ensure, or in some cases more directly, shall ensure that national environmental laws and policies provide for and encourage high levels of environmental protection and continue to improve levels of environmental protection. So that kind of language does become, or has emerged somewhat regularly in international investment agreements in recent years. Simultaneously, it's also become apparent that human rights considerations have lagged behind. Very often we'll find language such as, I'll highlight language from the Turkey-Uruguay Bilateral Investment Treaty, which is a somewhat recent agreement. Article 13 of that agreement highlights corporate social responsibility, and the language itself imposes obligations, and very soft obligations, we could say, on investors to voluntarily incorporate into their internal practices and policies internationally recognized standards of, among other things, human rights. So what we see here is a very well-recognized governance gap, right? That we have investors who have internationally enforceable rights against states. This has, of course, led to regulatory chill in the past. It's led to controversial cases based on the fair and equitable treatment standard and indirect expropriation standards in context of issues such as water rights, indigenous consultation requirements, land use regulations, among other issues. And we see that states, of course, as is well known, have a harder time enforcing obligations against investors, nor do they really bind themselves to improving national human rights frameworks via these internationally enforceable agreements. Most international investment agreements do very little to address this procedural asymmetry. Counterclaims have been highlighted often as a potential solution, but remain the exception and not the rule. And finally, even when states are able to overcome procedural barriers, there's still concerns about the role of investor-state dispute settlement arbitrators and their inherent backgrounds in investment and commercial law disciplines as opposed to human rights, natural resources, and sustainability. So there's quite a few barriers I think we could recognize in terms of integrating human rights considerations into the international investment law regime. In the brief minute or so that I have left, maybe we can think about what kind of solutions exist. I would argue that there's not a perfect solution given the current framework, but that doesn't mean we shouldn't consider what are some possibilities. And there do exist opportunities to increase regulatory coherence between international investment agreements, domestic human rights, and as well as natural resource obligations. And I see this sort of regulatory coherence between international obligations and domestic obligations being one of the keys to actually to improving the protection of human rights in relation to international investment law. Now, of course, that means that we have new generation international investment agreements which can be pursued, joint interpretations of old generation international investment agreements, which can perhaps help to better embed investor obligations into such old generation agreements and impose obligations on states to ensure that higher standards are implemented in the first place. Of course, sometimes complete renegotiation of problematic or termination, in some cases, of problematic international investment agreements should be considered. And finally, I also think it's important to ensure that the right to regulate is directly embedded in such agreements, even if it does have customary international law foundations. It's important to have express language preserving such a right in such international investment agreements to ensure that arbitrators are indeed taking it into consideration when disputes materialize. So to conclude, full consensus, for example, full consensus at the WTO does seem distant at this point in time. States should continue moving forward in their bilateral and particularly in their regional arrangements. There is plenty of forward-thinking language which can be found in regional instruments such as the AFC FTA protocol or various EU instruments, and it indeed may be in this context where progress can most immediately be made. And I'll wrap up there. Thank you.
Thank you so much to our distinguished expert speakers for those very stimulating contributions. It is now my great pleasure to introduce Sir Thomas Gauthier, who's the founding former managing director of the World Trade Institute, is Professor Emeritus of European and International Economic Law at the University of Bern, and is of course, a world-leading expert in international economic law with a particular focus on constitutional theory and intellectual property. Is led the Swiss National Research Council NCCR program on international trade regulation from fragmentation to coherence that I also had for a while the pleasure to be part of at the WTI. He served on the International Plant Genetic Resources Institute board. He held several positions in the Swiss External Economic Affairs Department, among many, many other roles. He also was appointed to the pool of appeal arbitrators under the multi-party interim appeal arbitration arrangement pursuant to Article 25 of the Dispute Settlement Understanding at the World Trade Organization. And he also very kindly agreed to speak into this plenary. And without further ado, I have the pleasure to give you the floor. Thank you so much, Professor Gauthier. Please, in the meantime, don't hesitate again to enter your questions for our speakers. Professor Gauthier, the floor is yours.
Thank you so much, Ilaria, and thank you very much for inviting me just to this prominent floor to address a few items. I do this in a somewhat gloomy mood because we all know there's no shortage of normative standards, whether it's human rights or whether it's SDGs here, but we all face tremendous difficulties in implementing these. When we use human rights, we all see that they are of limited justiciability in this area, and when courts apply them, it is immediately politically very controversial here. We face a landscape of emerging nationalism, which is largely hostile. We also face some reactions by businesses who want to push back the linkage between business and human rights and reduce obligations. We have an ongoing trade war between the United States and China, and we're going to probably see one also with the European Union. These are very, very bad conditions to advance your topics and your concerns here. So I was thinking, what is the role in this situation of researchers working in academic circles on these topics in that gloomy period here? And I would just like to encourage you to really focus on fundamental questions here, rather than simply following what's going on in international fora, which are not making any progress here. And from my experience and from my current work, I would just like to make 3 points. The first point is we can no longer afford to limit our considerations to international law. Most of us are international lawyers, but in fact, if we want to make progress, we have to adopt a framework of multi-level governance. Whatever the problem you're dealing with, you have to go down all the way to the local level to see how progress and implementation can be achieved. So we no longer have the possibility just to leave our discussions to the community of international lawyers, but have to go beyond that. And that, of course, is equally true for domestic lawyers who have to overcome barriers dealing with international law issues. So we need a framework of multi-level governance here, or how I call it, of transnational federalism. The second one is one Professor Lehman already addressed. I think we need fundamental research on production and process methods, PPMs, because this is a fundamental challenge to the principle of national treatment, and it is actually the key point in bringing about sustainable development using trade. But conceptually, there still is a lot of work to be done. We have incremental progress in bilateral agreements, but we are far from actually having achieved proper results within the WTO framework here. And then the third point I would like to encourage you is to go back to fundamental principles of law. And the principle I've been working on is the principle of common concern of humankind, because this is recognized in climate change, it's recognized in biodiversity protection, and I think it is the most fundamental proposition to overcome barriers between different competing or even hostile countries with different political systems here. So the principle of common concern of humankind is able to bridge a trade war between the United States and China, because there are a number of problems which cannot be solved in isolation. And the same is also true, of course, in relations with other trading powers at the European Union. But this principle is really embryonic, and I worked on it quite a bit, developing the basic obligation to cooperate, which is not a matter of course in international law. Secondly, to do your homework and then have compliance mechanisms here. But the academic community is not really taking this up because they are absorbed by following what's going on in international fora. And I was a former diplomat, so I know how to work in international fora, but I think that's not the job of academics. You have to develop your own agenda, and you have to make a contribution beyond what's going on in international diplomacy. Thank you very much.
Thank you very much, Professor Gauthier, for sharing with us these wise words of caution on the one hand, on these turbulent times that we go through, but also for your guidance and advice on key areas really that need the attention of the research community these days, which I think is really much appreciated. We now turn briefly to our interveners. Dr. Kennedy Mbeva, who is a researcher at the University of Cambridge Center for the Study of Existential Risk, with expertise in climate governance, international negotiations, and sustainable development, including representation of African states in multilateral environmental processes. Further, Advocate Pierre Leturc is a policy analyst with the Green Trade Network, focusing on the relationship between trade policy, sustainability, and human rights, including the EU's emerging regulatory framework on supply chain due diligence. Dr. Kennedy, your intervention, please.
Thank you very much, and I'm delighted to join the distinguished and esteemed panel and everyone else in the audience in today's very important deliberation. I start first and foremost by emphasizing the very important point that has been raised and articulated, that human rights are central to thinking about sustainability, whether it's a question of obligations for states and other actors, but also the question of enforcement. Just to add to the discussions, I think one of the interesting questions is thinking about the corporate actors that we might have in mind when discussing the question of human rights and business, and especially the context of economies where we have small and medium enterprises as the backbone of the economies. Of course, one could draw a distinction between, major corporations or multinational corporations and small and medium enterprises, and in terms of how they interact with the law, but also the environment. And so, the question that I think will be important is then how could we think about the context in which we have these smaller corporate actors, and how should we think about compliance with human rights and sustainability, and does that change substantively from the perspective of the multinational corporations? So I'll leave my intervention at that, and I'm very much look forward to responses from the panel. Thank you.
Thank you very much, Kennedy. We now turn to Pierre, please.
Yes, many thanks, Dr. Fabiano, and warmest thanks to our distinguished speakers for their fascinating opening remarks. So my question to the panel concerns recent developments in the EU's partnership strategy and the risks these developments may pose to the integration of human rights and sustainable development objectives into trade agreements. The deployment of the EU's economic security agenda has led to the conclusion recently of the EU-Mercosur agreement, following more than 2 decades of negotiations, as well as to an agreement with India, which is expected to enter the ratification process shortly. Compared with several earlier EU trade agreements, these agreements are noticeably less explicit in their commitments to sustainable development. At the same time, the EU has concluded a new type of partnerships, the first one with South Africa, the Clean Trade and Investment Partnership, which is designed to support investment in clean technologies in partner countries, while securing access to the CRM required for the EU's own green transition. Partnerships such as the CTIP, so the Clean Trade and Investment Partnerships, or the pre-existing critical raw minerals partnerships are, however, not legally binding. So do you see a risk that these developments, driven both by the EU's renewed emphasis on economic security and competitiveness, and by growing resistance among many global South countries to sustainability-related trade conditionalities, could undermine the progress achieved, the incremental progress that were mentioned already over the recent decades in ending sustainable development objectives within international trade agreements? And a second sub-question concerns the governance and institutional architecture of these partnerships. How can states better ensure that indigenous peoples, local communities, and underrepresented groups and minorities are meaningfully represented during the negotiation of these agreements, and more involved in the implementation and the monitoring of human rights and sustainable development related provisions? Thank you.
Thank you very much, Pierre, and indeed to Kennedy once again. We now will turn back to our speakers. I see that in the Q&A we have over 50 questions, which really speak to the relevance of everything that has been shared so far. Would any of our speakers like to respond? I open up the floor.
I could, if I may, take on Pierre's first question. So thank you, Pierre, for the question. But before I actually get to your actual question, just for context, I would like to note that and I do say this quite a lot, that the EU-Mercosur agreement is a product of its time in a way. So it reflects negotiations that started over 20 years ago. So I think it's important to acknowledge that this was before the emergence of today's more sophisticated TSD chapters and also the current wave of supply chain regulation that we've been witnessing. But to get to your actual question, I would say that yes, I do see a risk. But perhaps the most significant challenge, in my view, is the growing fragmentation of the legal framework that Professor Olawuyi also mentioned in his keynote, both in terms of international regimes and also domestic law and domestic institutions. So sustainability nowadays are pursued through a wide range of instruments, of course. So we have beyond trade agreements, we have domestic legislation, we have unilateral trade measures that Pierre mentioned in his question, the CETIPs, that Pierre also mentioned, raw materials partnerships and other forms of regulatory cooperation. So for me, the answer, the issue is less whether sustainable development should remain part of trade policy than whether these different instruments operate in a coherent and mutually reinforcing way. And as for unilateral measures, we do have several recent developments that illustrate the challenges with those. So we had unilateral measures formally making it into the climate COP agendas at COP30 here in Brazil, reflecting, of course, concerns from many developing countries about the implications of those unilateral measures for equity, development, and international cooperation. And also, of course, we have the EU CBAM and other aspects of EU climate policy challenged before the WTO by Russia. So together, those developments demonstrate that the measures designed to advance climate, nature, sustainability objectives must also be perceived as legitimate within the multilateral trading system and by the countries that are affected by them. So for me, and I'll wrap up here, if sustainability is pursued primarily through unilateral conditionalities, it risks, of course, generating resistance and the regulatory fragmentation that I mentioned that we want to avoid. But if instead it's advanced through cooperative frameworks, regulatory dialogue, capacity building, technology transfers, and more balanced partnerships in a way, I think we're far more likely to achieve both sustainability and development objectives.
I'd just like to come back on my point on the PPMs. I think the example of these agreements are very telling, because in most of the trade agreements I know, the chapters on sustainable development are separate from trading goods. And often they are also not subject to dispute resolution in the same way. So there's deliberately no linkage was made between these chapters and the key areas for trade on goods. And this is exactly the kind of challenge we face. How can we bridge these concepts and bring them under the same chapeau, under the same system of dispute settlement, so that these chapters are being discussed and litigated together and no longer separated?
Yeah. And if I can come in on some of the questions raised, including those typed. One, I think Thomas has covered the aspect of trade very eloquently, but I would also like to add in the idea of investment agreements. What we see on the ground at times is a desperation by states to attract investors, giving them very robust investment agreements, which in the end lead to regulatory, weaken the regulatory space for states to be able to maybe, for example, enact a climate law. You see a lot of arbitration challenges on new laws aimed at addressing climate change, saying, well, this is expropriation. When you brought us in, you never told us you were going to make a new climate law. So it starts with the investment agreements. And our working group released a report on investors, ESG, and business and human rights, highlighting the need to ensure that investment agreements do not weaken the regulatory space by states. And we see this in the current rush for critical minerals, in which a lot of countries are unable to even regulate their own resource because of the sort of agreements they've entered into. So that's one key area. And there's the question by Kennedy on the issue of SMEs, right? SMEs have key roles to play, but most of the time you see that the lack of capacity is often the issue. Many of the interventions that we see tend to focus on the big businesses, the big companies, the big corporations, neglecting SMEs, at times neglecting those in the informal sectors. And if you don't regulate the informal sector, then most of the problems we see with environmental challenges with artisanal mining becomes big, just as we have with the lack of capacity with SMEs. So I think there is a need to, at the domestic level, to ensure that we treat this not just as a big company issue. The SMEs can drive innovation, homegrown innovation, that could indeed address this issue. So there's a need to support them, provide capacity, provide support that will enable them to be able to leverage their innovation. And there is a question by Bichi that I see in the chat on the role of youth. And I think that's a very, very important aspect that we cannot forget to mention. One example I like to give is a group that, I was very impressed with them in Nigeria. They started this app called Follow the Money, whereby they can keep track of how much money has come in the petroleum sector, how much has been used to wisely, how much has been stolen. And that just shows how youthful innovation can be at the forefront of sustainable development. So I think there is a need to provide more opportunities for the youth to leverage their innovation. And I like to say that whenever we think about the youth, it's not just about campaigning or protesting. It's also about using their technology knowledge to advance innovative solutions that can accelerate the SDGs.
And if I could just follow up on a quick point, I've heard a lot of the panelists here today talk about the importance of domestic procedures, domestic laws, and that comes back to the point of regulatory coherence. I mean, I've looked at this from the investment law perspective, and I think it's really interesting to put enforceable language in investment law treaties. However, it loses impact when similar obligations don't exist at the domestic level, nor when procedures don't exist at the domestic level for parties, impacted parties, to pursue justice. There was a question in the chat that I saw when I was perusing, which asked about impacted communities, indigenous communities, workers, etc. How can they participate in investment law processes? Obviously, there's amicus procedures available. Obviously, there's reforms to the at Univ concerning the investor-state dispute settlement procedure. But in reality, very often the most direct way for parties to participate when human rights are impacted at a domestic level is through domestic procedure. So that coherence is extremely important and should not be neglected.
Thank you very much. Thank you to all of you. We now have a bit of time for our moderators that have been monitoring our online forums for important questions. Dr. Natalia, Dr. Jelly, and Advocate Matthew, would you like to share some of the questions or comments from our online audience? Dr. Natalia.
Yes, thank you so much, Professor Gehring. Thank you so much for everybody's questions and comments. They were really insightful. But the most common one, not surprisingly, which included questions asked by Hamid Baha Ayar of Afghanistan, Humphrey Shangufu Musenge of Zambia, and Talha Iqbal of Pakistan. I sincerely apologize if I mispronounce everybody's lovely names. And I think a bunch of others, not surprisingly, concerned most effective instruments that our speakers could suggest for making most impact for us to move from these voluntarily frameworks such as ESGs and such to actual legal enforceable obligations and making environmental due diligence, for instance, obligatory. And also, who do our speakers believe should be in not in charge, but who should be the main actor leading this process? Should those be international organizations or national governments and so on? And also, we had a few questions, including those by Dr. Kishore Shankar Dere of India, Nguyen Thi Nan from Vietnam, and Vivian Linden of China, that concerned more of a corporate angle of things. And those participants asked about the challenges, some insights into the challenges that corporations are facing, even those that are willing to comply with this framework and doing their best. They might have technological, financial, and other issues preventing them from doing so. And if anyone would like to comment on that, that would be wonderful. Thank you very much.
Thank you, Natalia. And we go to Dr. Jelly.
Yes. First, thank you. There are like more than 60 questions, and just monitoring all of them. Really like response are really very interested on trade, investment, and regulatory space. For example, Betul Ataman from Turkey, Rashmi Katpala from India, Talha from Pakistan, Charlotte from Switzerland, Sarah from UAE, and Kansa from Zambia asked how trade and law can better balance investment ability and government's ability to regulate in the public interest. Like what legal reforms or emerging models offer the greatest promise? And another question is several participants really were monitoring, including Crispin Ogaha from Tasmania, Sofri Musengi from Zambia, and 3 from South Africa, Mansa Gistar Christine, focus on enforcement and accountability. Meaning beyond adopting new laws, what institutions or mechanisms such as courts, ADR, due diligence obligations, or international legal principles are most effective in ensuring businesses are held accountable for environmental and human rights harms? Thank you, Marcos.
Thank you, Jelly. And we go to Matthew. Matthew, final set of questions from the audience.
Thank you, everyone, and thank you, Prof. Marcus. I think Dr. Natalia and Dr. Jelly have accumulated quite a variety of questions, but maybe just 2 that I will add. People are very curious, in particular, Charlotte from Switzerland and Rashmi from India have questions in particular for Prof. Alessandra on different regulatory mechanisms and different examples that you may be able to provide based on your work and your experience in response to some of your comments. I think we would love to hear your take on those. And then in particular, one from Paco of Belize, and I think a few others and a few of my colleagues too have been really, really interested in this from a young person standpoint. We're starting to see an erosion of international law and maybe some ideas about how to navigate that. I know Abdul Kamar as well was talking about advancing towards the SDGs. How do we kind of see some of those in tandem? So I think responses to those would be great. Thank you, Prof. Marcus. Back to you.
Thank you so much. Intriguing, fascinating, and challenging questions from our audience conveyed by our moderators. I'm giving back to maybe we start with the panelists and then go to the keynotes. Professor Lemon, and big shout out to our colleague Dr. Charlotte Siebergrasser, who's such a friend of CISDL and posed such a challenging question. Alessandra, you've got the floor.
Thank you. Thank you so much, Marcus. Thank you, Charlotte, for the very challenging and very timely question. I'll be brief as I see we're almost over time. I agree with Charlotte that perhaps the most intuitive example that comes to mind when it comes to trade policies that are conducive to fostering sustainability are perhaps preferential tariffs for sustainable goods. And I do also agree that those have produced mixed results. So they are complicated, there are certification costs, there's very complex rules of origin. But in my view, there's also some other initiatives, regulatory initiatives that we could turn to, such as market access incentives, investment facilitation provisions, corporate due diligence and sustainability obligations, particularly those stemming from the EU, despite the rollbacks, the partial rollbacks under the omnibus proposal, regulatory cooperation, as I mentioned before. But the conversation that I think we actually need to have is a conversation on subsidies. It's a thorny question, but it's also a long overdue question. So I think we do need to think disciplines on environmentally harmful subsidies. And I think the harder part of this conversation is perhaps that we're not only talking about the trillions in subsidies that are channeled to oil and gas industries, but also technologies and energy sources that have become economically viable at scale in their own right. So thank you for the question.
Thank you. And shall we go to Ted, please?
I think I'm going to defer to our keynote speakers. Unfortunately, there's a lot of noise where I am, and I'm not sure if you can hear me. So I'm going to defer right now. I'm sorry.
Fantastic. Yeah. Professor Damilola.
Thank you very much. There are lots of questions on the issue of how can we move from just rhetoric to action? How can we strengthen, have more sort of mandatory regulation instead of the soft law instruments that we've been using over the years? I mean, everyone has been waiting for the adoption of a legally binding treaty on business and human rights. It's been under negotiation for many years, and it has still not come to life. We do hope that it will come to life. Our working group is involved even in pushing for that, even though we are not the ones responsible for the treaty itself, but we are working closely with the intergovernmental working group that is responsible for it. So we do hope that some of the challenges being faced now will be overcome. I would think that countries should continue to engage with that process. A lot of countries, especially Africa, Asian countries, have not been actively involved. And that's not what you want. You want them to be involved because the end result might be a treaty that does not reflect their priorities and aspirations. But while we continue to push for that and do all of that, what should we then do? We cannot sit back and say, oh, one day there will be a treaty. So I would think that we can take the opportunity to also reform existing laws and their challenges. For example, we can integrate human rights due diligence in investment laws, in environmental laws, ensuring that no project, no activity can commence without that human rights question being asked and being addressed to satisfaction. We don't have to wait for an international treaty for that. There's the issue of access to remedy, access to justice. Why can't we use ADR to hasten the resolution of disputes rather than wait for 20 years in court? But in some countries, there are arbitration laws that restrict arbitration, for example, to only commercial disputes. So we can reform that and expand and say arbitration mediation should not only be for commercial disputes. If it's a land dispute, if it's a dispute involving businesses, we could use ADR. We've been pushing for that, and we hope to see that. So the bottom line is to also look for opportunities to enhance capacity development as well. We don't need a legally binding treaty for governments to increase their spending on programs that would equip the national human rights institutions to be able to raise awareness on this subject. So we hope that we can be innovative. Wicked problems like this require innovation. So we do hope that everyone can continue to innovate to ensure that businesses take human rights seriously and place people and planet above profit.
Thank you so much. And Professor Gonthier, Thomas.
Thank you, Marcus. I'd just like to have a word on enforcement and compliance. I think it's very important to recall that international law is not in a position to enforce the law. The enforcement of the law depends on the states. They have the power to do that. They have the means. And that has always been like this. So we can't hope that international law in itself will bring about enforcement. But that's not the essential point. The essential point is that we need to achieve voluntary compliance. I think international law and the law is most successful generally if people comply voluntarily. Whenever we have to enforce, this is linked to high costs and failures, etc. Whether that's in domestic law or in international law, it's the same story. So I think the goal must be to bring about voluntary compliance, which of course goes to what Professor Lehman said. We have to enter into cooperation. We have to provide incentives so that countries on their own actually are willing and businesses are interested to comply, for example, also by using tax breaks, etc., for those who are making the effort. There are many ways you can do. Now, when it comes to a failure of compliance, I think then we go into the question of enforcement. And enforcement basically ends up in countermeasures, which countries may take. But that again requires that the country has the willingness to impose these measures here, which also do come at the cost. But this is a matter of domestic politics and domestic law, and that's why I think it's very important to always consider all the layers of governance when we address these questions. The main point again is develop strategies to bring about voluntary compliance, but have a fallback, because there needs to be carrots and sticks. And this is what we developed under the principle of common concern of humankind in the compliance sector, a system of carrots and sticks which can be used. Thank you.
Thank you, Thomas. Thank you, Professor Gonthier, and thank you to all our interveners. There's so much more we could discuss. I refer to all the co-hosting institutions of this plenary panel. And without further ado, I give the floor back to our colleague Fabiano.
Thank you, Marcus, and indeed, thank you very much for all speakers for joining us today. And I think sharing not only your wisdom and your experience, but also interacting with the audience in such difficult and challenging questions. We understand that we are going through exceedingly turbulent times, I think, and on the one hand, evidence continues to mount on the challenges that we are facing and will continue to face on climate in particular, but also all kinds of other environmental challenges. And on the other hand, our geopolitical and economic context will continue to challenge our existing legal and governance frameworks in business, trade, and investment issues. So conversations like the one that we are having today are not only timely, but also key and an open invitation, in my view, for us to continue to discuss these issues outside of today's gathering, but also for researchers and scholars that are watching to really take on the issues such as the recommendations of Professor Gonthier on what must be the research agenda for us to really come up with innovative solutions to this. It's really imperative that we do so. So with that, I declare that we really conclude our second expert plenary for today. I think it has been an excellent discussion. We will now take a 30-minute break for lunch, but be sure not to go too far. Coming up at 1 p.m. Eastern Time, will be our 2026 Gonthier Memorial Lectures, as well as the announcement of our 2026 Weeramantry International Justice Award laureates. So please be sure not to miss that. Thank you very much again, and lovely to see everyone.